Everyone who follows the Delphi murders case has had their eyes on the calendar waiting for June 15th, 2023. That was the date the bail hearing for Richard Allen was scheduled to take place. Well, now things have changed. That bail hearing has been changed into a suppression hearing. What could be behind that change? Does it mean the defense has changed its strategy? What exactly can we expect to have happen at a suppression hearing? Could the results of this hearing be dispositive? In other words, could it bring about an end to the case against Richard Allen? And how long should we expect it to take Judge Fran Gull to make her decision in the matter? To get answers, we turn to Shay Hughes, a public defender in Indiana. You can find Shay on Twitter and Instagram as the Hoosier Public Defender. His legal analysis is top-notch, and we really recommend you check out his social media. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
We first connected while looking into the Burger Chef murders, an Indiana cold case. Together, we built a spreadsheet documenting hundreds of cases of restaurant-related homicides. That original spreadsheet gave way to our podcast, The Murder Sheet.
Now we maintain that same research-centric, investigative approach as we look into all sorts of homicides, including unsolved cases, historical crimes, and, of course, restaurant murders.
We don't just chat about the headlines. Our podcast is a platform for our journalism. The Murder Sheet focuses on investigative reporting, thoughtful analysis, thorough research, and in-depth interviews. We're the Murder Sheet.
And this is The Delphi Murders, a conversation with the Hoosier Public Defender about the upcoming suppression hearing. So basically, earlier, what was going to be happening next week was a bond hearing, and now it's become a hearing to suppress. Does changing from one to the other indicate there is some sort of strategy change on the part of the defense in your mind?
It potentially. They very well may think that they have an issue that ultimately is dispositive of the case. Then, when you have a major suppression issue like that, then there's really no need to procedurally go through a bail hearing if ultimately evidence is going to be suppressed, is going to be dispositive of the case. And, worst case scenario for the state ultimately means the case needs to be dismissed, then it doesn't make any sense to proceed with any type of bail review hearing.
What exactly happens at a suppression hearing in Indiana? Should we expect to hear any witnesses or evidence?
You should definitely expect to hear witnesses and evidence be presented. Generally speaking, for the most part, it's usually the state that will put on evidence. They'll call officers. They'll present. They'll have testimony, just like you would for any other evidentiary hearing. That may be a little bit different if they're challenging a search warrant. At that point, search warrants are presumed valid, and so the burden is on the defendant. I will say, though, in my experience, I've only, I think, challenged maybe 2 search warrants. Both instances, I think the court kind of handled it a little bit differently. The state ultimately put on evidence, but generally speaking, you should expect, law enforcement officers to be called There very well may be exhibits entered into evidence. I simply don't know. But yeah, I mean, it would be just like any other evidentiary hearing.
You said you've only challenged yourself a couple of search warrants. Is it unusual for a search warrant to be challenged?
It's unusual because I think it's very difficult for evidence seized pursuant to a search warrant to ultimately be excluded from evidence because, again, there's a presumption that search warrants are valid. And even then, if a search warrant is found to be invalid, if officers relied on it in good faith, then the exclusionary rule, which means excluding evidence obtained in violation, does not apply. And so it is very difficult for defendants to challenge search warrants.
It sounds like it. So what kind of grounds would you need, in theory, to successfully challenge a search warrant in Indiana?
You would really have to prove that on its face, the search warrant lacks probable cause. And then you'd have to show that the warrant was based on false information that was knowingly or recklessly supplied by law enforcement, or that it was, again, facially deficient. You read through it, you can tell on its face there's not enough there for probable cause, that the issuing magistrate was not detached or neutral. I've never really seen this come up, but I will say, this did come up in a case of mine, and I think it needs to be challenged by defense attorneys more often. You will find out that judges sometimes are giving advice to law enforcement. So, hey, they look at a search warrant, they say, hey, look, I need the following information. They'll have that discussion with an officer. Well, that's a problem because now you're giving advice. You're no longer neutral and detached. But that I don't think has ever been addressed in Indiana. And then that the affidavit or sworn testimony upon which probable cause rests is so lacking in an indicia of probable cause as to render the official belief in the existence of the warrant unreasonable. Again, it's pretty difficult. I think there was a recent case where the United States Supreme Court kind of expanded good faith under the Fourth Amendment, and that basically that case says that police mistakes that lead to an unlawful search that are the result of an isolated, negligent incident rather than a systemic error or reckless disregard for constitutional requirements, the exclusionary rule does not apply. So essentially, it broadens the scope of good faith to the exclusionary rule. And you have to talk about really a massive error by police. Now, with that said, it appears that Indiana has not adopted that SCOTUS case under its own constitution. So there's that as well.
You said you had a case where a judge basically gave advice to law enforcement about formulating a search warrant?
Yes, I have a case currently up on appeal, and I didn't challenge that necessarily. I mean, I drafted a pretty thorough footnote, but essentially, in the case that I had dealt with, there's a conversation between the law enforcement officer and the judge, where the judge said, "Hey, look, I need to know how you referring to the officers arrived at the residence that you provide in the search warrant." You can see where the problem relies on something like that, right? There's no one in the affidavit that provided that communication. And, judges shouldn't be providing any type of advice to law enforcement, right? If there's an issue, then they can go to the prosecutor, they can go to a city or county attorney to seek legal advice. It shouldn't come from a judge.
Yeah, that seems like common sense. You wouldn't expect a judge to provide advice to the defense, for instance. So right. The same standard should apply. Since the conduct of the issuing judge may be relevant, is it a factor that we haven't seen the search warrant. We can presume, I imagine, that it was probably issued by Judge Diener, who's no longer in the case. So is there any significance to it being evaluated by a different judge?
No, I don't think there's any significance in terms of, who evaluated it. And again, I want to stress this. 99 times out of 100, there's really no issue with the judge or magistrate that issued the search warrant. With that said, though, I am sure that there are more instances going around where, there's a conversation going on between a judge and the officer seeking the search warrant, and that's not recorded at all. And it's just something that defense attorneys need to be mindful of when challenging search warrants.
Again, we don't know the details of this motion for suppression. Sometimes a motion like this will hinge on the action of law enforcement at crucial moments. Because of that, the testimony of officers can be tremendously important. Oftentimes, that testimony will be in the form of a deposition. In your Instagram post about this, you also highlighted the fact that no notice of deposition has been filed. Can you explain exactly what that means and why you find it significant?
Sure. There's a trial rule about providing, and filing notice of depositions. I guess theoretically you could conduct a deposition without filing notice. But I would just I would expect that there would be a notice filed, in a case such as this. I mean, you would want everything to be reflected on the record, right? Just because of the significance of this case. But it appears that no notice has been filed, and we have really no information that a deposition or depositions have been conducted. Generally speaking, you would, for the most part, conduct a deposition prior to any type of suppression issue. That way you kind of lock in a law enforcement officer in terms of their testimony. But there are instances where you don't. If, the error is so egregious that there's just no way you could save it or supplement your prior testimony, then there's really no need for it. Or if you don't really want to show your hand, so to speak, and give the prosecutor an opportunity to kind of clear up the record, that would be another reason why you wouldn't bother with a suppression. And I could say personally, there have been instances where, I don't find it necessary because everything's on body cam. I have a police report already where the officer provides a statement. There's, the conduct kind of speaks for itself. And a deposition just simply is not necessary.
The murder sheet ensures that we stay busy, running around and reporting on true crime stories.
That means that HelloFresh has become a key part of keeping our week less hectic. This is America's #1 meal kit for a reason. We've enjoyed the journey of becoming at-home chefs and preparing delicious meals without blowing our budget or wasting a ton of time. One recent dish we really enjoyed was the spicy Peruvian chicken and loaded rice with pickled jalapeno and creamy salsa verde.
The chicken was nice and tasty with plenty of spicy flavors. HelloFresh really knows how to pick out ingredients, so you're getting that farm-to-table feel.
One thing that was almost as good as the food was the peace of mind knowing that I didn't botch a grocery trip and forget a key ingredient. We could just be in the moment and have fun cooking together.
Whatever your goals are this summer, consider HelloFresh. If you're looking to connect with friends and family with some backyard cookouts, then keep in mind their crowd-pleasing options like snack boards with pretzel bites, spiced bar nuts, and hot honey peach jam. And if you're trying to mind your health and eat well, you can opt for the Calorie Smart or Protein Smart options. Go to HelloFresh.com/MSheet16 and use code MSheet16 for 16 free meals plus free shipping. Again, go to HelloFresh.com/MSheet16 and use code MSheet16 for 16 free meals plus free shipping. That's HelloFresh, America's #1 meal kit. Now, of course, we haven't actually seen the suppression filing. We haven't even seen the search warrant for the house, we're just assuming that the suppression hearing is covering the fruits of the search warrant, I guess basically the gun.
This, of course, is the gun belonging to Allen that can allegedly be linked to an unspent round found at the crime scene.
Would it make any difference if theoretically Allen had consented to the search? I've heard some people speculate about that.
It could make a difference. Consent to search is an exception. You don't need a warrant when someone consents. With that said, Indiana is a little bit different in terms of, if you're considered to be in custody, then a law enforcement officer needs to make you aware of the ability to consult with an attorney prior to giving consent to a search. And that's known as your PERTL warning or your PERTL rights. So that could be significant.
Yeah, of course, in this case, there's reason to be concerned that Allen didn't actually have attorneys for quite a while. So until well after he was incarcerated. So are you saying that could play a factor in all of this?
The fact that he didn't have an attorney in the beginning or, with him when officers were searching, no. The big thing, at least when it comes to PERTL warnings, is just simply when a person is in custody, they have to be informed of their right to consult with an attorney about the possibility of consenting to a search before valid consent to be given. So if you're in custody and I simply ask you, hey, will you consent to searching your home, and you simply say yes, and I search it, well, that's an invalid search because you were in custody, and I should have said, hey, look, before you consent, I just want to make you aware you have the right to consult with an attorney. I'd have to give that warning. The fact that he didn't receive an attorney, at the initial hearing and so forth, that wouldn't factor into something like that. It would simply be at that moment in time determining whether or not he was in custody. And then if in custody, did an officer provide a sufficient PERTL warning to him?
In your experience, is a judge likely to make a ruling on these type of hearings pretty quickly, or does it take a while?
Well, they have up till 90 days to make a ruling on an evidentiary issue such as this. So I've found an experience that it generally takes at least a month and sometimes up to that maximum of 90 days. And I would probably expect the same. I'd probably expect somewhere in the neighborhood of probably about 80 to 90 days to come to a decision in reference to this case.
Can you elaborate on why it would take so long?
Yeah, it just really depends on the complexity of the issue, especially if it's an issue of first impression. From the court's perspective, they want to get it right, and they want to do a thorough reading of the record, and that ultimately takes some time. So, and generally, courts also provide, after a hearing, around 30 or so days to submit any briefing by the parties. So there is some dead time, I guess, in respect to the court as well during that 90-day period.
And we've talked a little bit about how this could potentially be dispositive. Of course, we don't know all the evidence that the prosecution might have. The heart of the case, from reading the PCA, seems to be a gun they recovered from the Allen home, which could be linked to a bullet left at the crime scene. If, in theory, something that important was suppressed, would it be dispositive? Would it, in theory, end the case?
If the gun was excluded from evidence because of an illegal search or seizure, that necessarily would not be dispositive, but you would have, a huge problem for the state in terms of meeting their burden at that point, right? Because it appears from the probable cause affidavit that the one thing linking Richard Allen to the scene is the firearm that was located in his home, and then this bullet, this round that was found on the scene, right? And then that a lab analyst analyzed both the gun for tracking marks and so forth, and came to the conclusion that it appears to be objected from the same firearm, right?
Right.
Well, if that firearm's excluded, then you don't have that evidence, right? So no one could ever testify about that. So then you're really just left with, it'd be even less circumstantial evidence, to the scene and about his whereabouts. Theoretically, though, factually, would that make it itself would not make it dispositive, but it would be a huge blow to the state.
So after a ruling, whether it would go for the defense or the prosecution, would the other side have any recourse or the opportunity to appeal the ruling before the case proceeds?
They certainly can. They can file for an interlocutory appeal. Really, there's basically two hurdles when it comes to an interlocutory appeal. You have to have the trial court agree to certify the order that's going to be appealed. In other words, basically the court says, yes, you can appeal this order. And then you go to the appellate court and you ask the appellate court to accept jurisdiction over the case. And they basically have to say, we will take the case and address that specific issue while the case is currently pending. To meet that, you're essentially talking about, significant cases, right? That there will be substantial damage or harm to the defendant or to the state if this was left to be decided after the case was tried. That there's judicial economy, right? I mean, this is the one issue. It's dispositive or close to dispositive. It makes sense to address it now than to wait afterwards and so forth.
And you mentioned that it's difficult to win a suppression hearing involving search warrants. Is it difficult just generally to win a suppression hearing?
It is.
Why is that?
There's many exceptions there are many search warrant exceptions. I think that's one thing. I think generally a lot of those exceptions give almost deference to law enforcement. And that ultimately makes things difficult. So I think for those reasons, it always makes it difficult for defense to win on suppression-related issues.
I know you're a public defender. Do you feel the weight is tilted too much in favor of law enforcement in these sorts of hearings?
I would say generally, yes. If I can expand upon that, I mean, I think, a lot of the case law is kind of devolved into something else. There's been more deference given to law enforcement on cases. For example, Terry v. Ohio.
Terry versus Ohio is a 1968 Supreme Court decision that basically decided the police can do a stop and frisk of someone if the officer has a reasonable suspicion that that person may be involved in a crime.
I don't know. In some instances, that was a vastly different case that was decided back in, I think, was late 60s or early 70s, with that type of officer who specifically knew about shoplifting incidents and, was trained on that versus kind of what we see now. So I think ultimately there is much more deference given to law enforcement, considering nervousness, or things that just may be kind of innocent on its face, furtive movements or gestures, these things that are very difficult that you subjectively believe, right? I mean, I know it's supposed to be on objective criteria, but it seems like there's almost a combination of subjective observations that are then considered to be objective when considering the totality of circumstances that ultimately make any type of detention lawful. And that becomes difficult for defense counsel.
So you're saying if the law enforcement officer says, I see furtive movements or whatever, that can be used as a pretext?
It could be used in considering the totality of circumstances, when detaining an individual, yes. And you have these instances where things are just so difficult to challenge because they're not recorded, or you don't have a good point of view, even if body cam is activated. Even the legality of some traffic stops, whether or not there was a traffic violation that was occurring. The traffic violation itself, you'll find oftentimes, despite there being in-car video available, wasn't activated in a timely fashion. And then we are entirely dependent on an observation made by the officer, right?
Right.
Now, to me, I would say, in a circumstance like that, having the ability to record something, that it's not arduous to make a recording, to activate in-car video, you're simply pressing a button. You have about 30 seconds to do so, to record based upon what you observed, because it pre-records every 30 seconds. That essentially, if you fail to do so, that should be inferred against the state. But if have I had success in getting courts to agree with me with that? No, I have not.
I have to tell you, we've gotten emails from people who are upset and even frustrated that hearings like this take place at all. They feel that if there is evidence that might implicate a person, that's all that matters, and these other things are things that shouldn't matter. How would you respond to that, and what would you tell them?
Well, that's what, I don't know. I think this kind of goes to the heart of the Constitution, the heart of our state, right? It's important. I think we value privacy, and, to simply allow government to intrude in terms of the private areas of your life is just not right. You should not have to live under government scrutiny 24/7, 365. They should be held to a standard. We should not have to, look over our shoulder and see government standing there, right?
Right.
We value privacy rights. It's why we have a Third Amendment. It's why we have a Fourth Amendment. It's why we have the Castle Doctrine. It's why we have, something similar under essentially every other state constitution. And oftentimes the state constitution provides even greater protection.
Another question we've gotten is, in a case like this, is there likely only to be this one suppression hearing, or should we expect to see other suppression hearings come up as the case progresses?
You very well could see, a couple suppression hearings. It's not unheard of. Does it generally happen? No. Usually for judicial economy, you try to address every suppression hearing in one motion and in one evidentiary issue. But there are times where things come up, you overlook something, you receive a new discovery disclosure from the state, you realize, hey, there's an issue with the way this evidence was obtained, and I have to file something additional.
Is there anything else on the issue of this suppression hearing or the case involving Richard Allen at all that you'd like to address?
No, other than, I think what, you make a good point that maybe they are focusing on the handgun that was recovered. I think more generally, they very well could just be challenging the arrest itself. That they're claiming the arrest of Richard Allen was not supported by probable cause, and therefore everything must be suppressed. That's very general. I've never filed a suppression related to such an issue. But that very well could be the case. And then that makes sense why you would convert a bail hearing to a suppression hearing, because essentially, you're kind of, not the issues overlap, but they are pretty parallel to each other, right? The bail hearing, you're essentially saying there isn't sufficient evidence to hold them no bail. Well, in the suppression hearing, if you're challenging the arrest, you're simply saying there's not there's not probable cause for the arrest of Richard Allen. If it was pursuant without a search warrant, and then if Richard Allen's arrest was pursuant to a search warrant, then again, same thing. You're challenging the search warrant itself.
So if the arrest itself was held to be without probable cause or whatever, does that basically mean that's dispositive, the end of the case?
It very well could be dispositive of the case. Now you're kind of getting into the exclusionary rule and fruit of the poisonous tree and so forth. But I would say at that point, if there was an arrest made without probable cause, then yes, it would be dispositive of the case. I don't believe you could make an argument from the state saying, well, the arrest doesn't relate to this other evidence and so forth. I think that presents a huge issue.
Yeah, it's going to be very interesting to see what happens later in the week.
Yes.
I'd like to take a moment to thank Shay again for sharing his expertise with us. You can find him on Twitter and Instagram as the Hoosier Public Defender. His legal analysis on this and other cases is absolutely top-notch, and we really recommend you check out his social media. Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening. Hello, Murder Sheet listeners. Thank you so much for sticking with us until the very end. Just wanted to take a moment as we close out to thank our sponsor, HelloFresh, America's #1 meal kit. They are #1 for a reason, folks. Kevin and I have been loving the meals we're getting from HelloFresh. We're talking farm fresh produce, protein, all sorts of customizable options to get you exactly what you and your family need. It's very delicious, it's very nutritious, and it's quite affordable. So it ticks off all our boxes. We've been very happy with the service. And, would love for you guys to try it out if you're curious, or if you've tried it out in the past and enjoyed it, get that discount. It's hellofresh.com/msheet16. And then you're going to plug in the code msheet16. You get 16 free meals plus free shipping. You can't beat that. We've really been delighted by it. We work very hard on the podcast. It takes up a lot of time. It's our small business. We really enjoy the work. We enjoy conversing with all of you every week. But at the same time, it's nice for Kevin and I to kind of have something to do outside of office hours, and cooking these meals has been really fun. We're terrible in the kitchen, like disastrous. I mean, like I can tell you horror stories. I probably shouldn't get into it on the podcast, but I mean, some pretty disastrous moments involving our cooking. Nothing life-threatening, but definitely stuff that we tried to be overly ambitious about, and it either went horribly wrong or it ended up costing like way more than it should have because we didn't properly like think about ingredients, and we're not gifted in the realm of the kitchen. But HelloFresh makes us pretend like we are, because everything is so pre-portioned and pre-planned, and the instructions are super clear, so like you're not going to mess it up if you're like us. And if you're good in the kitchen, then it's just less of a hassle, and you get everything that you need. You don't have to run out to the grocery store. So super nice. Try it out. I've really enjoyed the meals that they've sent us so far. I can say that Kevin has too. I highlight that because Kevin is pretty picky when it comes to food. He does not like everything. He has pretty strong specifications and preferences, very much cares about things like fresh produce and farm produce and things like that. So he's very picky, and I think the fact that he is really enjoying HelloFresh is a testament to the quality here, because he's a stickler for that kind of thing. And so if you are, I think you will enjoy it as well. And again, the URL and promo code that'll get you a sweet discount is hellofresh.com/msheet16. That's MSHEET 16. And use code MSHEET16. You're going to get 16 free meals plus free shipping. We hope you enjoy it. And again, thank you so much for listening.